All right. Hello, everyone, and welcome to another one of our NPS Empower Hour sessions. Our topic tonight is shutdown resources and how we advocate for members during our shutdown, and things that the union can do to support you in a shutdown. So my name is Stephanie Snow. I am the organizer, the NTEU organizer that has been working with the Pacific West region to organize. And I'm joined tonight by Lee Fisher, who is my counterpart in the IMR region. And we are really pleased to have a special guest tonight with us, Sam Wegleitner, who is one of our NTEU Assistant Counsels, otherwise known as field reps. In some cases, you may have heard that with other unions. And so Sam is with us tonight to give the field rep perspective, also to talk a little bit about what is it that a field rep does, because once you get organized and you form your union and have your election, you will be working very closely with a field rep just like Sam. And so it's good to know what it is that our field reps do and how they work with our members for advocacy and all other things. So I'm going to turn it over to Sam now to let Sam explain a little bit better about the role of a field rep or an assistant counsel, and then move into our topic for the evening, which is information about shutdown.
Thanks, Stephanie. Thanks, Lee. Thanks, everyone who's involved in this organizing campaign. You are making a tremendous difference, and looking forward to bringing this and other chapters across the finish line. So, as Stephanie said, I'm an assistant counsel with NTEU. I've been in that role for about 6 years within our organization. The assistant counsel role is one that kind of wears many hats with the local groups of unionized employees. First and foremost, I'm a legal advisor to the local chapters and members for any issues that pop up during the course of your federal employment. It could be a discrimination question. Oftentimes, the issues arise under negotiated collective bargaining agreements, which once you finish the organizing process and get that across the finish line, we'll begin to organize your contracts. Those could be issues that pop up with whether or not you're approved for telework, whether or not you're approved for a 410 schedule. If you get a performance evaluation that you don't agree with, if you're getting disciplined or counseled, any of those things are ripe to reach out to your local union stewards, or if you are the local union steward, to reach out to me to seek guidance on how we address those issues. What are our options? Can management actually do this? Do we have any legal or kind of strategic recourse to try to remedy these issues that are popping up? So an example could be, you had an off-duty incident where you were erroneously charged with a crime or something, and now management is trying to take an action against you. We can step in and try to assist that. Another option that we've handled, and I personally handled all the way up through an arbitration, is we had some scientists who were traditionally doing kind of triaging plants that came across our border to check for pests, mites and blights and other diseases. And their agency wanted them to do a totally different line of work and start inspecting travelers for weapons and narcotics and things that, these people had gone to school to be scientists. And so that is kind of tangible to some of the things that you might be experiencing or expected to experience under this administration as we look towards the future. So the field rep is essentially a liaison between NTU National and the chapters. We seek to answer questions as they pop up from members and from chapter leaders. We try to guide and ensure the chapters are providing effective support to their members. So we put on trainings for local leaders and try to get out and meet with members on a regular basis to make sure that we're available to answer their questions as they pop up. And I'm sure we all have a lot of questions around the shutdown and the RIFs. And if you have any questions, feel free to throw them in the chat. Stephanie, Lee, and I will try to answer them as they come in. Certainly at the end, we'll open it up for questions again if you have any. Stephanie, are there any specific kind of topics or questions we want to talk about related to the shutdown? In terms of what NTU has done, I'm happy to kind of share my thoughts, but happy to have you chime in as well.
Yeah, I have some ideas, but before we get to that, just circling back around to your role as an assistant counsel, can you just briefly describe sort of the structure within NTEU of field offices and assistant counsels in those field offices, just to give people sort of a picture of how closely our chapters are associated even geographically with our assistant counsels.
Yeah, of course. So we have obviously our headquarters in DC that has some of our administrative staff, some of our national negotiators, and some of our lobbyists right there on the Hill to do that direct advocacy work with agency leaders and legislators. But we have kind of our direct service groups that are our field offices located throughout the country so that we can get in touch with employees frequently and be as readily available as possible. So we have 7 field offices, I believe. We have one in Oakland, one in Denver, one in Austin, one in Chicago, one in Atlanta, one in Hoboken, and then one kind of slightly larger office in the DC area. So I'm actually based out of our Denver office, and I serve six, now 7 different groups of employees in the Pacific Northwest across several different agencies. And so the field staff, the assistant counsel, the national field rep, is really the kind of first point of contact that many of your chapter leaders or members will have when they have issues related to uh, things that pop up related to their employment, whether it's a legal question, whether it's a, hey, we want to do a barbecue, are there any issues with us having a raffle to raise money for the union? Those types of things are great questions for me, and I'm responsive to chapters to try to help them build out, the strength of their chapter, but also build strength through litigation and grievances and those kind of paths and mechanisms as well. So outside of the field office, which I'm a part of, back in DC, we also have national negotiators who primarily negotiate the national collective bargaining agreements that outline the various rights that we can obtain for you as federal employees. We negotiate some of the best contracts in the federal service. Their volumes of rights that we enshrine for employees, and we go back and forth with the agencies every 4 years, every 6 years, every 3 years, depending on the length of the contract. But we discuss, kind of almost every aspect of your federal employment, from your leave request to, whether you're telework eligible, whether or how agencies should treat your leave requests. Just every aspect of federal employment, we try to negotiate into that collective bargaining agreement. And as soon as we get some sort of new right passed at law, like parental leave, for example, we try to enshrine that into the collective bargaining agreement in case the law gets changed down the line. Those rights will live on through that collective bargaining agreement. Stephanie, any other things you want me to touch on related to the organizational structure?
No, but your last point was a really good point about even the things that we get by law, we like to enshrine those into the contract to live beyond the law if the law would change. I think that was a really good point to bring forward.
Oh,
Let's move.
100. Oh, I was just
Well,
gonna
go ahead.
say, like over the last 8 months, it's been incredibly important because the contracts, we might have a 4 or 6 year contract, and because we have that contract in place for our unionized employees, administration can't just come in and say, you're not entitled to telework, or you're not entitled to these rights that we fought so hard to get. So it provides a barrier from the politicization of our federal workforce, so that we can have, stable rights and that they live on and in between, these more politicized times.
Thank you. Yeah, let's jump right in. Can you just give an overview of sort of and timeline of the shutdown? I mean, I'm sure as federal workers, the folks on this session are aware, but just to kind of put everything in perspective of how we've gotten to today, um, and then we'll move on to like some other questions about that. So just a big picture.
Yeah, of course. And I wouldn't say that I'm like the utmost expert on this, but the fiscal year ended September 30th, and Congress wasn't able to pass a funding bill to keep the government open and funded beyond the fiscal year deadline. So currently there isn't agency funding. Um, how that operates in practice for federal employees, and many of you are probably know this already or have been privy to it in previous shutdowns, or if this is your first one, you're getting up to speed through gossip, through reading the news, hopping on Reddit, or whatever you're consuming and trying to get information from these days. But generally speaking, there's a few different groups of categories that employees can get placed into during a shutdown. The agency can furlough you. You can be determined to be exempt, which means basically your funding stream is unaffected and that you're funded through not the normal appropriations process, or you're an accepted employee. Accepted employees are kind of forced to continue working because they've been deemed that this work must go on, but they're not paid during that time. Furloughed employees traditionally weren't guaranteed back pay during the furlough status. Most times they would actually receive back pay once the government was funded once again. However, in 2018, 2019, during that shutdown, we were able to pass and advocate for the Government Employees Fair Treatment Act, which guaranteed back pay for furloughed employees. So we fully expect, or under the law, furloughed employees are entitled to back pay for the furloughed time. And so we will certainly advocate for that. And if we have to file a lawsuit on behalf of federal employees, if the current administration threatens to not provide back pay, we will certainly fight for those employees as well. In terms of timing for how long this could go on, I don't have a magic 8 ball. I think the latest is that the House is not going to reconvene until October 14th, after Indigenous Persons Day next Monday, or Columbus Day, which would be next Tuesday, a week from now. It's possible, if the Senate pushes something to and reaches agreement, the House could come back earlier. I think that's probably unlikely, but that's my own personal opinion, so take that for what it's worth. I believe the longest shutdown under the previous Trump administration was about 35 days. I have seen just personally some shifting on the Hill, and even out of the White House being a little bit more responsive to some of the sticking points from the Democrats related to healthcare issues. So we'll continue to monitor that. I would say we have a tremendous legislative staff here at NTEU that monitors these issues, that has relationships across the aisle, and has a really, really good pulse on what's going on the Hill, not only on shutdown issues, but all issues that affect federal employees. And you probably tracked some of that. When the big, beautiful bill was passed, there was some talk about, going from a high 3 to a high 5 for employees' retirements, or other issues that we were able to successfully push off as part of that fight. Um, so that's, I guess, where we're at with the government shutdown, is kind of triaging which bucket employees will go into, whether they're furloughed, whether they're accepted, whether they're exempt, monitoring that because that can change. Accepted employees can be furloughed at some point in time as well. And then hoping that we're able to pass either a continuing resolution to get it restored, or, a more concrete funding bill to get more stability within our government.
I didn't want to unmute. Um, so can you, as an assistant counsel, give your perspective of a shutdown. Like, what does it look like on the ground with you working with your chapters, either in this shutdown or the past shutdown? What are the things the conversations you have with your chapters and the way that you support them and advocate for them during this shutdown period of time?
So, one of the kind of one of the many negatives of a shutdown is some of our chapter leaders don't get to use their normal work time to engage in their traditional union business. And so oftentimes what that means for me is I'm trying to help them still process the things that need to be taken care of. We also try in some of our contracts to get some favorable language to allow us to still get some of that union time. If there's, for example, the agency wants to take a personnel action against the employee and wants to interview them or wants to take some sort of action against them, we might be able to get official time, depending on the contract language, to allow those employees representation during that process. A lot of it is uh, trying to make sure that we're preserving any grievances that we want to file. If the agency is using this period as a period to try to steamroll changes because the union's not able to do the normal union work. How our contracts and how the law works is deadlines are told for filing grievances so that as soon as the shutdown is over, we click back on, we're able to file and process those grievances and secure remedies for any kind of unlawful or conduct that the agency is taking that violates the collective bargaining agreement. So part of it is guiding the chapters through that process. What are the issues that we can engage in representational activity on? What are things that we might have to wait? How do we make sure that we're organized around these issues so that we don't lose track of it as we push through that? There might be other questions that pop up too. How can we still convince the agency outside of kind of a litigation strategy to stop them from taking X, Y, or Z action? And we do a lot of that kind of soft diplomacy or just conversations and strategic and persuasive approaches. And so I will still do that. And during the shutdown time, NTU National takes on more of that burden because of some of the limitations that some of our reps have during this time, whether they're furloughed, whether they're in an accepted status and being denied the representational activity time. We step in and help fill that void or that gap during those times.
Thank you. And Lee, anytime that you have a question that you want to, ask Sam, just please step in. Otherwise, I'll keep going. Can you talk just a minute about, so you've talked about the things that we do sort of organizationally and representation wise, but what are some other things during a shutdown that NTEU has done to support workers just like as a community to bring community together and just keep workers engaged with their union, but also we're helping in other ways other than like legal ways and contractual ways.
Yeah, 100%. I mean, I think I don't know about you, Stephanie, or you, Lee, but many of us within NTU staff, but also within the broader NTU organization, view this as, I know it's cliche, but a family. And with long furloughs, there can be financial stress, there can be all sorts of other stress, and we try to be there for each other, whether it's emotionally or whether it's a food bank or having a happy hour or being somewhere that we can vent or come together to really be in this together because I think that's a really important piece of what unionism means as a federal employee or as just part of the broader union movement. I've worked with chapters that have done things from fancy Christmas. I mean, this is a non-shutdown time, but elaborate Christmas parties to having a softball team, to going to baseball games, to having summer picnics and having barbecues. And so there can be a social function in this, but also a social support network in this as well, because sometimes there isn't a whole lot we might be able to do on a particular issue, but you just need someone to talk to, or you need someone to just validate the frustrations, the fears, the anxieties that a lot of us are experiencing right now.
Do you want to add anything to that, Lee?
I mean, yeah, I can certainly add in terms of answering the question.
Yeah, like maybe some of your personal experience or an example of your personal experience building community.
Yeah, I've worked with some chapters who have actually set up kind of like clearinghouse offices where they were available and had office hours every single day throughout the shutdown to direct people to different resources. NTEU.org, we have a shutdown page that we've created that's just for members, for people who pay dues. This is one of those benefits of being a member. But we offer connections to, and I've seen chapters connect people directly to food banks, like Sam mentioned, but also other resources within their local communities that are helping with like utilities, resources that are helping people reach out to. And like there are a lot of templates to reach out to different creditors during shutdowns, helping people walk through that. Not exactly a shutdown thing, but definitely as new requirements have come out, like new resume requirements, having that mentorship and helping people prepare for what those next steps look like. I've seen a lot of chapters do pretty amazing things around that to connect people to what they need in the moment.
Great, thank you so much. Um, so you kind of touched on this, Sam, earlier, but I want to kind of circle back around to it again because especially today, this has been a big news item, and that is you talked about how back pay is guaranteed by law since 2018-19. But there's been talk that this administration is moving towards not issuing back pay. And so I was wondering if you could just touch on that a little bit, and that you did kind of mention NTEU stance, but just kind of circle back around to it.
Yeah, yeah, of course. I'm sure it's on many people's minds, so thanks for revisiting this. But we noticed yesterday that some OMB guidance had been updated to omit a sentence guaranteeing that furloughed employees will receive back pay during a shutdown. But like I said before, it's our opinion that that is just blatantly incorrect. The language, the specific language of the Government Employee Fair Treatment Act of 2019 says that it's not only for this shutdown or this furlough, but future government actions after something like December 22nd, 2018, or something like that. So the plain language, I think, gets rid of that. And I think even I saw earlier today, I want to say on GovExec, or one of the kind of federal employee news media outlets, that obviously the Democrats were pushing back against this, and some of the president's statements on this, but also several Republicans who were involved in that bipartisan passage of the bill. And it was actually signed by Trump in 2019, but are very skeptical of the president's position, and are going to stand up for federal employees, and the previous law that was passed that is directly on point.
And then the other topic that has been, kind of on people's minds and worrisome to people is all of the talk about RIF and RIF related to the shutdown. And so I thought maybe you could just give us some insight into that.
Yeah, so the RIF procedures, and again, many of you employees may know the specific procedures for a specific agency better than I do, but there are complex rules and regulations about how a government RIF must take place, and that requires specific notice, and then a whole kind of series of processes that play out. And where we represent employees, and we've negotiated a collective bargaining agreement on behalf of those employees. Sometimes we allow for continued negotiations over the RIF, even after that notice is given that the agency wants to go through that process, or we've negotiated what that process actually looked like. So it could be, what amount of notice is required? Does an employee have transfer opportunities? And if so, how does experience crediting go into whether or not they're going to be considered for those other opportunities? How does Vera or VSIP or retirement options or early retirement options or buyouts, all of that goes into those discussions with the agency. And so if there are going to be RIFs, we expect and we are going to hold agencies accountable that they have to go through the legal process. And we've already been in litigation this year regarding unlawful RIFs. And we've had some success in the courts already, where the agency has just gone ahead or tried to go ahead of RIFs without giving the appropriate notice periods. So there's a question here from Nicholas Graver. Based on how things have gone this year, do you expect DOI to honor the 90 or 60-day RIF notification requirements in the WASO CBA? I haven't looked at that CBA in particular, but if that is the language of the CBA and they don't give that notice, then it's likely that those RIF notices are invalid. And so like we've done in some of our other cases, we'll try to invalidate that either through the courts or through the grievance and arbitration and appeal through the FLRA process. So, looking at this administration and trying to guess, what laws or what provisions are going to follow, I think could be a fool's errand. But our reaction to, any violations of law or of a CBA would be to take aggressive action to make sure that it is corrected and that employees are getting the rights that we fought so hard for.
This is actually a good place. I got a question of like, what is it like dealing with this administration right now, where we actually have contracts that are being upheld? So not in our agencies that are currently excluded, but what does it look like enforcing a contract and having a union under this current administration?
So I can't say it's been rosy, it hasn't been perfect, but there are things that I think still there's been a lot more litigation because we've had to push back and we've had to file against the agency more frequently than we have in the past, where there was kind of an understanding that if there are laws or rules in place, you can't just steamroll them. And thank goodness we have the collective bargaining agreements that we do in our agencies that allow us to correct those violations and to correct those unlawful actions. But there certainly has been a lot more litigation around some of these issues that we've already talked about. The return to office violates a lot of our collective bargaining agreement. Some things around performance appraisals we've seen violate our collective bargaining agreement. How they've treated probationary employees, for example. We had to file a lawsuit to protect many of those probationary employees that were terminated and then restored to duty, and many of them were able to successfully complete their probationary period during the pendency of that lawsuit. So that was a kind of a great, easy, tangible victory that we had on behalf of these employees. And in some of our agencies and with some of our managers, it has been, as much as I can say it, business as usual, where there are collective bargaining agreement provisions that have been around for 10, 15, 25, 30 years, and the agency is respecting those, and we've been able to maintain some resemblance of normalcy as we navigate this kind of crazy, tumultuous time. Great kind of comment question, Lee, there. I appreciate that.
Can you, we've got a couple of questions in the chat, but before that, I think we all understand, but I think it's always good to give context. When you say that we've got lawsuits and we've got litigation, what do timelines kind of look like on that? Like, do we get an answer right away and get resolution?
So the general answer is no, but it can really depend on the case and what the government does in response to our filing or to a local or lower level court opinion. So and this is going to be a little bit technical, but some cases we actually can't go directly into the courts, and we need to file or we're channeled into the grievance and arbitration process, where we're arguing about whether or not a contract article applies to a particular situation, or if it involves a singular employee over, whether or not they're entitled to X, Y, or Z. We might have to go through the grievance and arbitration process. However, if there's kind of this concept of irreparable harm, and we can't wait to go through that grievance or arbitration process, we can file directly in federal court. And when we file in federal court, we can ask the judge before we actually go to kind of trial or a drawn out process to get to the bottom of whether or not the agency's action is legal or not. We can ask the judge for an injunction, and an injunction is kind of a legal measure that stops the action from taking place while the judge tries to sort out whether or not it's legal or not. So we've been able to secure some injunctions to try to stop the harm. And those actually move pretty quickly because you're saying, hey, I need emergency immediate relief, because if you don't grant this relief, there's going to be harm that's not curable. The classic example is some actor wants to cut down a tree, and you're saying, we think it's illegal for them to cut down the tree. We need to stop you from cutting down the tree during this process to determine whether or not it's illegal or legal action to cut down that tree. So a lot of it's felt like this administration's trying to cut down our trees, and we've been trying to, have to chain ourselves to them or take some sort of old school organizing actions to try to stop that. But maybe we can try to move to some of the questions in the chat, unless you had
Yeah,
anything else you wanted to
that's
add,
great.
Lee.
Thanks.
And Stephanie and Lee, feel free to hop in. I by no means think I'm like the foremost expert on any of these issues. I'm just sharing some of my experience and some of the information that I've picked up in this role. So Katie asks, if the RIF notice you discuss is in a CBA, would that necessarily affect union members? Uh, Oh, my guess is that is that referring to maybe non-union members? I'm not entirely sure. I think, if you have a RIF notice that requires the agency to give X amount of days notice and go through a specific process, and that is in a collective bargaining agreement, that would apply to the bargaining unit that collective bargaining agreement covers. So it would depend as the National Park Service gets brought up. It's possible that there will be a national collective bargaining agreement. It's possible that there will be local collective bargaining agreements. I'm not necessarily privy to what that might look like, although it's possible that I might get a chapter, especially if we get some parks up here in the Pacific Northwest, that I think there's been some folks at Rainier and North
Yeah.
Cascades and other spots, which is awesome. And I met a few folks down at the federal building a couple weeks ago with Stephanie to chat with them about this. So to answer Katie's question, I'm not entirely sure, but so long as you're covered by the collective bargaining agreement and you're in that bargaining unit, those notices should apply to your specific situation. I'm just going to run through some of the other questions, if that's okay with Lee and Stephanie. Charlotte asks, how do y'all work with unions like AFG on lawsuits? And I'll say we've worked with them every step of the way to come up with strategic responses and to make sure that we're filing in the right areas to preserve our rights and to make sure that we're being as effective as possible. We do represent slightly different groups of people, which could strengthen or hurt certain cases, depending on the types of employees we represent. But we are hand in hand. We understand that this is a unique time for federal employees, and if it's possible that we've had conflict in the past related to we want to organize park service or we want to organize park service or this or that, but like we don't have time for those disagreements right now. We're in a different time, and I think all parties understand that we're kind of in an existential crisis mode with this current administration. And so, to answer your question, Charlotte, we're working with them, hand in hand, and we're all on the same team here. And there are other federal sector labor unions that we've been involved with our Office of General Counsel and some of our strategic partners, both kind of behind the scenes, but also on the forefront of litigation over these lawsuits. Um, Shout out to Nicholas for the tree cutting. JRH asks, when you file a lawsuit to uphold a legal right for government employees, is it always specific to CBA? If not, can the case ruling apply more broadly or only to NTEU unionized employees? So it depends, JRH, where that legal right comes from. Some of the rights may only be a right or an entitlement to the employee because it was negotiated into the collective bargaining agreement. Some of our collective bargaining agreements say the break room will have a microwave. And so sometimes we have to file a grievance that says the agency took away our microwave and we want it back. Obviously, something like that wouldn't necessarily apply to other employees. But if we're filing a lawsuit over something much broader, it certainly could affect employees both in bargaining units or even employees not in bargaining units. And there are mechanisms outside of traditional grievance and arbitration process that we do on occasion. One that comes to mind is we file EEO discrimination complaints on behalf of employees. And that might be to stop harassment, a hostile work environment for several employees who are experiencing a manager who's engaged in discrimination. Some nice funny comments there. Bree asks, how does the union work with an employee when a RIF notice is issued? So I'll just speak from my experience. I mean, the first thing that we do is we want to try to understand what the notice says, and make sure that the employee understands what the notice says and what their options are. If the agency goes through a lawful RIF, they're going to give this notice. In a perfect world, the employee will say, "Hey, my local union steward, I just got this notice. Can you help me understand this?" They'll talk through it. They might reach out to me to say, "Hey, RIF notices are going out. Are these correct?" We'll take a look at it to make sure it's consistent with what we've heard at the national level with what's going to happen with this group of employees. Then we'll make sure that the RIF mechanisms are operating appropriately. Does that employee have a right to one of the early retirement options? Does that employee have a right to some of the bumping procedures based on their experience or based on other less senior employees, generally speaking? But it's much more complicated than that, and so oftentimes the agency does screw up how the bumping and transfer opportunities and procedures. So we monitor that and we make sure that the employee gets their rights during that RIF process. Travis has asked a follow-up question, and to expand on those, if we are not unionized yet, though working to that goal, how does the union work with that? So I'm not entirely sure because I've only worked with chapters who have already unionized. And so maybe that's better for Lee and Stephanie, how you work to share information, during with employees during the time when you're kind of getting up and running.
I'll attempt it and then Lee can add to anything that I leave out. I would just say, what we're looking at and what's being talked about in terms of RIF are these broad, sweeping kind of things. And so it's likely that even though you don't have a contract that has specific RIF language in it yet, you would follow regulations. And so anything that we do more on a national scale is going to trickle down to you, even though you're not organized as one of our chapters yet. And so, for instance, we have the WASO in Chapter 336 We have a contract for each of those NPS chapters. And so we would be looking at seeing, how a broad sweeping RIF violates those contracts, and then any movement or action that we get out of that in terms of winning back rights or halting the RIF would probably bleed over then, because they're talking about doing this like agency wide and department wide and things like that. Lee, do you have anything to add to that?
Yeah, and this actually touches on the next question about representing people in front of MSPB, but that's a potential other route that we have a lot that we definitely are have taken on because of how many people have been impacted that we're working with partner firms as well to help represent people. But I can say that in the past, during organizing campaigns, if people have signed an 1187 and some sort of action gets taken against them, that we treat those people as if they were a member of our union to the extent that we possibly can. We don't necessarily have a contract to be able to grieve and uphold, but where we can represent employees, where they can choose their own representative. We have generally done that for folks who have taken that commitment to be a member of the union. I don't know, Sam, if you want to add anything more about all of the RIF cases we have in front of MSPB. I don't know if you have any of those.
I don't have any of them. I can kind of touch, you probably saw some folks that were probationary employees that were let off or let go and then got brought back. And that's kind of, to Stephanie's point, where other litigation may affect employees. And some of the judges have authority to grant relief outside of the specific party because some of the lawsuits we're bringing on behalf of a broader class of employees than just the locally affected employees. And then, yeah, to Lee's point, there are some other mechanisms outside of the collective bargaining agreement, grievance and arbitration process to try to resolve some issues. And that includes this MSPB, which is this Merit Systems Protection Board, which can hear government employee appeals that aren't subject to the collective bargaining agreement, or where a union, for whatever reason, may not take a case, you might still be able to take it to the MSPB.
Really great questions coming in, and we really are at the question and answer portion of this. And so you can either keep continuing to put those in chat, or if you want to raise your hand and unmute yourself, you're welcome to do that as well. So while we wait for any additional questions, I did want to kind of touch on we are close to filing for an election for our Pacific West region. And so we're hoping to do that once the shutdown is over and we can, we have a functioning government again. But I wanted to touch on what are the rights, like after we file and after the election happens, we won't have a contract right away, but you do pretty much day one have some rights to representation once your union becomes certified. And I don't know, Sam, if you can speak to that.
I
Like
can
change.
certainly try. So one of the main things that we have is obviously to negotiate the collective bargaining agreement, but we have additional rights whenever the agency tries to change a working condition and or a condition of employment. So as soon as you are organized into a union, the union has the right to negotiate with the agency every time they want to change in working condition. Now, those negotiation or negotiability rights depend on what the agency's action is. And so sometimes we can actually bargain the substance of an action, whether they can or can't even do this in the first place. In other scenarios, sometimes they can do it. We can't stop them from doing it, but we get to negotiate the impact and implementation or the how they're going to go about doing that. So we might not be able to stop them, for example, for doing the RIF, but we get to talk about how that RIF might look like or what that process is going to look like. We might not get to negotiate, stop them from renovating the office, but we get to negotiate over what that renovation is going to look like. So that starts kind of day one, as Stephanie said, those negotiations to preserve and to protect and to expand your rights as a federal employee and try to mitigate any adverse impact on whatever it is that the agency is going to try to move forward with. And we'll probably see a lot of changes as the agency kind of continues to push forward with various just kind of traditional initiatives or initiatives that are more top down. Looks like Nicholas might have a question, a hand raised.
Um,
Yeah, sorry, I just wanted to go off of that. So we're looking at like various iterations of like when this RIF hits. We know it's planned for quote unquote mid-October. We don't know whether the government will be open or not. Um, we don't know when we'll be able to file or not. And so I'm curious about like the various iterations of like we file and then the RIF lands the day after, or like 2 weeks after, or like at what point is NTEU able to invoke those contract negotiations, et cetera? I know that's a complicated question.
I think in terms of maybe the organizing timeline, that's maybe better for Lee or Stephanie to talk about, just because I'm less familiar with that process. So sorry.
so there, while we're in the process, so let's say we file a petition today, and the government's working and all that, and they wanted to do a RIF. It really depends on the kind of RIF that they're trying to do. If it's a lawful RIF, which there's been a lot of talk about some of the ways that they're trying to do this would not be lawful. But if it's a lawful RIF, they do have the right to do that during our petition process. And we would try to preserve the bargaining unit to the best of our ability until the election. If it's unlawful, then that's a whole other, a whole other system and process, and probably we'd be talking about lawsuits and that sort of thing. Typically, I mean, in the past practice has been once we file a petition, everything kind of goes on hold until it's all sorted out, and the election, proceeds and happens. But this is not a typical time for us. And certainly, we can't rely on this administration to follow past practices. And so that's kind of where we are.
And just to piggyback on that point, some of this stuff we don't know right now. We're not sure what their actions are going to do. And one of, I think, the most important resource that we haven't talked a lot about today that the union provides to employees is information. And so if you aren't already checking out the NTU website, get on the NTU website. It has tons of resources. Even if you can't access the members only side, there are a lot of there's a lot of public facing information there. And it's being updated, around the clock right now because things are changing so rapidly. So you might get information there on RIFs, get information there on the shutdown, what's the latest coming out of Washington. And so we're going to continue to share the most up-to-date information directly with members as we learn more and as things change during this process. And it's my intention, and I'm sure Stephanie and Lee's, to continue to share as much information as possible every step of the way. So even if we don't know a specific answer right now, as we move through this process, we'll get more information and continue to share that with you all.
Great point. And we're going to be talking about this in a minute or two anyway, because we're going to be talking about our upcoming Empower Hours. But until then, I mean, I think it's important to note also through the NTEU webpage is we do have an action section or an action page on our website where you can use that page to help you take action. And, I think now is a good time to start utilizing, if you haven't. I know a lot of people are already doing a lot of actions through, 5 calls and all different kinds of things. But it really is important that your voice be heard. And so we're inviting you to go ahead and, don't wait to take action, take it now. But also, we are going to be having a legislative Empower Hour on October 21st, where we will have someone from our legislative department talk about all the things happening on the Hill, and then also how you can take action. And then we're going to be planning a day of action that we can all participate in together, and hopefully pull in also our NPS chapters from WASO and Chapter 336, and maybe some other individuals, to help us have just a really massive NPS action day to really raise the voice. So mark that in your calendar. It will be October 21st at the same time period. So it's just a regular Empower Hour time slot. But we also had intended for before the shutdown happened to use tonight's time slot to talk about performance evaluations. And we still think that is a very important topic, even though shutdown was a little more timely. So we've added another Empower Hour for October for next Tuesday. So we just pushed the performance evaluations topic to next Tuesday, the 14th. So Empower Hour on the 14th. About performance evaluations, and then the legislative action Power Hour on the 21st of October. There was one question in the chat that we just didn't quite get to yet, and that was from Bree. Does a union help review, file an MSPB appeal? And I think you touched on that, Sam, but if you might want to just circle back around.
So yes, we do. In some matters, we're what's called the exclusive representative. And so we're essentially, if you have a collective bargaining agreement, the only person who could file a grievance or go to arbitration. Generally speaking, with an MSPB appeal, we are not the exclusive representative. And so we do file, and I have filed MSPB cases on behalf of employees, but also we work with outside law firms, or people find their own attorneys to help them on MSPB appeals as well. So generally, when there's a process that is kind of outside of the collective bargaining agreement, but it's a kind of a legal process to resolve a complaint, or like the EEOC, for example, is another avenue where we're not the only people who can file on your behalf. You can do it on your own. You can get outside counsel to file a discrimination complaint against the government. So MSPB, the Merit Systems Protection Board, operates that way as well. But we do and have done those in the past.
Other questions? We still have about 5 minutes to squeeze in those last questions. Lee, do you want to add anything before we go?
Charlotte asked, that representation is free for union members, correct? Yeah, I can't think of a time where we've ever charged a member for any of our representational services. The only, I wouldn't say exception, but caveat is in some cases where, say, you were removed from federal employment, we get your job back, you get your back pay, NTEU gets attorney's fees. Sometimes there is a tax implication on the attorney's fees that we win when we get your job back. But, it's generally still very much a celebration when we win your job back. And so we'll walk you through that process as it comes out. But that is the one exception where there might be a tax implication for the attorney's fees we recover in a successful back pay case.
Not a question, but we did have one of our organizing committee members with us today who wanted to share about why she's supporting the organizing campaign, and reminding folks that if you haven't signed your 1187, that is how we first get to the election. And then second, make sure that we have a strong union to continue to fight and do all of the things that we've been talking about this evening. You can do that at nteu.org/NPS. You'll see a couple of big buttons that say sign your 1187. You can do that there. And I would love to introduce Charlotte to talk a little bit about why she supports a union for NPS employees.
Thanks, Lee.
Welcome, Charlotte.
Hi, everybody. My name is Charlotte. I'm one of the organizers in the Intermountain region, working on the regional office. And I am participating in organizing and believe in unionizing the NPS because we all love the NPS. A lot of us, we're so mission driven. We believe in what we do, but we all know that there are things that could be better, long-standing things as well as newer issues. And with a union, we're stronger together, right? We'll have more of an opportunity, more power to make changes, to help the NPS be a better place to work, and give us better opportunity to accomplish our mission. So like Lee said, if you haven't signed your 1187, please do that, because we want to get to election. And also go tell your coworkers. We want to get the word out there that this is happening, whether that's in a place already unionizing or a place that might be interested in it.
Thanks, Charlotte.
Yeah, thank you.
All right. There's a comment that's in the chat. I'll share for the recording, that says the union provides a mechanism to go to bat over our rights against the administration. Non-unionized employees don't have much recourse. It's great to have help. Yeah. Well, do we want to any closing remarks? Final questions? Sam, any final remarks you want to share for NPS folks organizing?
I just want to say, thanks for all your hard work. Oftentimes there's a lot of work that goes into these campaigns. Thanks to Lee, thanks to Stephanie, thanks to everyone on the organizing committee. It's really important that we have all hands on deck for this fight. You guys are the kind of front line employees preserving our democracy. So thank you for what you're doing, and we're here to fight alongside you.
I just want to thank everybody for joining us tonight, and also to kind of piggyback off of what Charlotte was saying. Now is the time, and we are really close in both regions where we're at a point that every signature matters. And so, obviously the folks on this session care enough to be on this session, and probably a lot of them have already signed. But if you haven't, we really need you now. And if you have already signed, we need you to talk to your coworkers and make sure that people who have been on the fence, or putting it off, or just haven't done it yet, just let them know that really now's the time, because we can bring this campaign, to fruition. And even for the Pacific West region, even though we're getting close to filing, every park matters to us. And so we want to make sure that when we file a petition, we're including as many parks as we can on that first petition. And I'm sure IMR feels exactly the same way. So even those small parks, some of them may have 7 to 10 employees. And so if we can get 4 or 5 people to sign, they're at their 50%, and, and we can include them in that first filing. So it really does. We are at the point where every voice matters, every signature matters. We're, as Charlotte said, stronger together. So that's my final thoughts for the evening, and just saying thank you for joining us.